Good morning, students. In our previous lectures, we have already discussed what is the concept of law under Article 13 of the Indian Constitution, what is the understanding of law according to the different schools of jurisprudence, as to the approach that is taken up by different theorists in order to understand the term law. We also looked into the connection between law, justice, and morality. It is an undeniable fact that law plays a significant role in the maintenance of society. It is that aspect which is intertwined with the lives of people, as it governs the conduct of people right from their birth to their death. Such body of rules are termed as law that controls the activity of members of the society. However, there are different laws that are available in order to govern different situations. In order to understand such situations, it is essential to understand the classification of law. The classification of law is based on different bases. To broadly explain the classification of law, it has been broadly taken up as national and international law, as civil and criminal law, public and private law, and substantive and procedural law. When we talk about classification of law, in order to understand the application of law under different situations, it is essential to understand what are the bases for making the classification of law. There are mainly four bases that we can categorize. On the basis of territorial limit, that under which the classification as national and international law falls. Second, on the basis of parties to the conflict, that divides law as public and private law. Third, on the basis of nature of the offense or wrong done to the party, under which it is categorized or classified as civil and criminal law. And lastly, on the basis of law applicable, under which we deal with substantive and procedural law. To start with the understanding of classification law, we shall start with the first basis, that is on the basis of territorial limit, where the law is divided as national and international law. Talking about national, or what we can also call as municipal laws, these are such laws that are applicable within the nation or within the country. They are basically territorial in nature and apply only to a particular territory. They are also referred to as domestic laws as they govern the relationship of the state with its subjects or of the subjects among themselves. Such laws include center laws, state law, territorial laws, regional or local laws at different levels. These laws operate however within the territorial boundaries of a country. These are such laws on the basis of which a court decides a matter. The sanctions, punishments applicable in case of any offense or wrong done to the parties are applicable as per laid down by the state, and such sanctions are applicable within the territorial boundaries of a country. However, when we talk about municipal laws, these municipal laws can be further divided into public and private laws. To say that a national law or a municipal law can fall under two categories, that is public and private law. That forms the second criteria, that is on the basis of the parties involved in the crime. The public law can further be divided under three categories, that is constitutional law, administrative law, and criminal law, whereas private law can be divided as civil and criminal law. Let's understand as to what do we mean by public laws. When we talk about the term public laws, these are the laws where the state activities are largely regulated by the laws that are recognized at the central level or state level or local level. These are such laws that determines and regulate the organizations and functioning of the state. They also determine the relationship of the state with its subject. To understand, it is important to understand as to what is the literal meaning of the term public. When we talk about the term public, it implies either the state or the sovereign part of it or body or any individual who is holding a delegated authority under the state. Such authorities, such body are referred to as public in nature. It is that branch of law that regulates the relationship of state with its subjects, and it can be further on that basis it can be further divided as constitutional law, administrative law, and criminal law. Before moving to the understanding of constitutional law, administrative law, and criminal law, it is important to understand what do we understand by private laws, as this is the second category that falls under the classification on the basis of parties involved to the dispute. When we talk about the term private, the literal meaning of the term private is referred to as individual or group of person or unit of state, but it does not refer to the term state itself. It is that branch of law that governs a relationship between the parties, that is, two individuals or two persons. It is concerned with the rights and liabilities of these individuals towards each other. When we talk about the term person, it includes not only the natural person or a human being, but it also includes artificial persons. Under private matters, state only act as an arbitrator through court and does not regulate all the matters of dispute between the parties. To say it only regulates those matters which are considered to be of public importance, but in case of private matters, it acts only as an arbitrator. This is the reason why private law is also known as civil law and is often is in contrast with criminal laws. The discussion with respect to civil laws and criminal laws shall be taken up in the next lecture. For the purpose of this lecture, we need to understand that what are the examples of private laws. Like for example, law of contract, property laws are such acts, the laws that are talking about the matters between the parties, where their private disputes are resorted to before the court of law. In other words, private law is that which is chiefly intended for ascertaining civil rights of individual. It regulates and governs the relations of citizens with one another. The parties are private individuals in such cases, and the state decides the dispute among the people. To further explain, private laws are enforced by granting the individuals the right to take actions in defense of a recognized personal interest, the sole purpose for which most private laws rules have been created to protect the individual interest. These private laws are such laws that enables an individual to fight for his or her own interest and rights that exist or subsist in under certain situations. As already stated, like for example, under the Contract Act, if there is no performance of a contract, then parties can move court for the performance of the contract in order to secure interest and in order to secure compensation or damages that are suffered by one party in case of non-performance of a contract. Such laws that governs the relations of individuals are termed as private laws. The classification of the law as public and private law was under the national law. Now, when we started with the discussion of public laws, we have discussed that public law was again categorized as constitutional law, administrative law, and criminal law. The part of criminal law shall be taken up in the next lecture along with the with civil law, where the classification is made on the basis of the nature of the offense. In this lecture, we shall cover as to what do we understand by constitutional laws and administrative law. Constitutional law is a part of public law. When one talk about constitutional law, it has been defined or considered as a grand norm. To say it is the law that is above all other laws that are applicable in a nation. It is that law which is considered to be the highest norm of the land, and all other laws must be inconsistent with the constitutional laws. These ordinary laws derive their validity only from the constitutional law. Any law that does not uphold the constitutional norms is considered to be invalid. This is the reason that every law is framed or laid down in conformation with the constitutional law of a country. To give an example to all of you, we have already discussed Article 13 of the Indian Constitution that talks about inconsistency of the laws that are framed against the Part 3 of Constitution. From there, we can derive that constitutional laws are considered to be the highest norm of the land, and all the laws must be made in confirmation of these constitutional provisions. And such laws that are framed as against the constitutional provisions can be challenged and thus can be held invalid. The constitutional law consists of articles and schedules that provide with the rights, duties, liberties of nationalist citizens and as well as that of the state as juris person. It defines the composition and procedure of the parliament, what should be the functioning of centers, state, local governments, and also defines the nature of the state and structure of the government. Constitutional law forms the basis of a nation and it defines the entire structure of a legal system. Now let's talk about the administrative law. When we talk about administrative law, it is that branch of law that defines and explains the administration of the government and the government bodies, and thus helps in convenient administration of the state. It is that branch of law that deals with functions, powers, and structure of the organs of the state. Further, it also deals with the exercise of political power of the organs of the state, but such exercise is done within the limits of the Constitution. The purpose behind defining such functions, power, structure, and even the exercise of political power is to protect the citizens, to guarantee the protection of the citizens against arbitrary acts of the authority. Thus, administrative law seeks to prevent the miscarriage of justice. To give examples under administrative law, writ petitions are the best examples that can be given under the concept of administrative law. When we talk about administrative law, it do overlap with the constitutional law, and there is a difference between constitutional law and administrative law. In order to understand the difference between administrative law and constitutional law, it is important to understand that administrative law is that branch of law that deals with organizations, powers, functions, and duties of administrative authorities, whereas constitutional laws deals with the general principles relating to the organization and power of various organs of the state and also the relationship of these organs with individuals. Despite this difference, there are many definitions of administrative law that are included within the concept of constitution. In order to understand the difference between administrative law and constitutional law, we shall refer here the difference as stated by Holland. Holland says that the constitutional law describes the various organs of the government at rest, while administrative law describes them in motion. Thus, the structure of the legislative and executive comes within the example of constitutional law, whereas their functioning comes within the aspect of administrative law. In other words, constitutional law deals with the fundamentals while administrative law deals with the details. Another difference that can be made between constitutional law and administrative law is that the constitutional law emphasizes upon the rights, whereas administrative law emphasizes upon the needs of the public. However, when we talk about the countries which have constitutional law written, like in India, the difference between constitutional and administrative law is not as nuclear as that exists in countries like England. To say, in such countries, the source of constitutional law is constitution, while the source of administrative law may be statutes, statutory instruments, precedents, as well as customs. Another difference that can be made out, or we can say the explanation is that constitutional laws deals with the structure and the broader rules which regulate the functioning of the authorities, while administrative laws deals with the details of those functions. Despite these differences, it is an undeniable fact that every person who is studying administrative law has to study the constitutional law as well. This is the reason that administrative law overlaps with the provisions of constitutional law. In today's lecture, we have discussed as to what do we understand by national law and how national law is divided into public and private laws, where public laws include administrative constitutional laws, criminal laws, and private law can further be divided into civil and criminal law. We have discussed what do we understand by public and private law, and then we have discussed constitutional and administrative law. In next lecture, we shall see the second category, that is the international law, the distinction between civil and criminal law, as well as of the substantive and procedural. With this, I end my lecture. Thank you very much. Have a nice day.